Good afternoon, everybody. Welcome to the next of our Essential series and a very happy 2026 to you all. For those who don't know, I'm Lottie, founder of the Juris Society. We are a community and concierge that explores what wealth means to modern women by providing them with the financial and legal knowledge to take control of their wealth and well-being with confidence. So today we're joined by Hannah Mantle and Emma Jones of Forsters Law to break down the probate process. This session is designed to bring clarity to an area of estate administration that is often misunderstood, emotionally demanding and time-sensitive, particularly for families managing complexity alongside grief. So this afternoon, we're going to explore what probate actually means and what it involves in England and Wales, when it is required, and how the process unfolds in practice. So from the early administrative steps through to asset distribution. Please note this is for educational purposes only, and if you do have any questions, feel free to pop them in the chat, reach out to myself, Hannah or Emma directly. So let me just get the ladies in. Hello both, good afternoon, how are you?
Hello, good, very well, thank you.
Thanks for having us.
Welcome, really, I wouldn't say excited about this talk, but really enthused about actually what you guys are going to be covering, because it is one of those topics that can be really difficult for people if they are not prepared. And I think this is all about preparation and understanding, and who better to learn it from. So I'm really grateful to have you both here. Before we get kicked off, could you just describe who you are and what you do to help your clients?
Of course, my name's Hannah. I'm a partner in the contentious trusts and estates team here at Forsters. So I tend to get involved when there's a dispute, but also looking, as you say, with the planning, stress testing scenarios and thinking about where the potential areas for dispute in future might arise.
And I'm Emma. I'm a private client lawyer who specialises in UK estate administrations. So I do all of the non-contentious side of things and end up working with Hannah's team if disputes do arise.
Perfect. Thank you both. So just, I guess, to get started, could you explain what the probate process, or what probate is and what it is not?
So in a nutshell, probate is the legal process that confirms who has authority to deal with a deceased person's estate. But the grant of probate itself is the key generally needed to unlock and administer the estate, but it's not the entire process.
Yeah, and I think it's important to note that it is a post-death process. So if, for example, you're acting as an attorney or a deputy for someone during their lifetime, that authority ends on death, and it is a new process, potentially with a new person involved as executor going forward. It's also the case that you can't front load probate to the extent that you can deal with any of the aspects of it during lifetime.
And today we aren't just talking about the application for the grant of probate, but it's the whole estate administration process, which is the journey from death to final distributions. Broadly, probate is where an executor appointed under the will applies for a grant of probate. However, if there is no valid will, a representative can also apply for a grant. So the estate administration process applies to both. And reference made in this session to the estate administration and personal representatives apply to both situations. Obviously, there are really straightforward estates where you wouldn't necessarily need to get advice, but we find that most people appreciate some guidance and reassurance that they are doing things properly, as there are many moving parts and obligations. And one thing that we want to flag at the outset is that if you are charged with administering an estate, this is a personal appointment where you will be under strict duties to do things properly. And ultimately, you may be held personally liable if there are any loss, or if there is any loss caused to the estate. There are also various deadlines which need to be met and kept in mind, such as payment of inheritance tax before interest starts to accrue, and completing deeds of variations if personal circumstances have changed.
Yeah. And equally, I think if things are looking contentious, or they are becoming contentious, where there's disagreement about the validity of a will, where someone feels that they haven't had sufficient provision under that will, for example, then it's usually worth speaking to a solicitor earlier on.
Yeah, and good point on actually acting, with good timings. What stage do you suggest you take legal advice, and what are the circumstances? You just touched on this actually, Emma, where probate isn't required at all. Like, what determines the threshold in practice?
So I think the key question that a personal representative needs to ask themselves at the outset is there anything about this estate that could create legal, tax, or personal risk if handled incorrectly? And most of the time the answer is yes. So due to this and the various deadlines and duties I just touched upon, it is important to get advice as quickly as possible so all of this can be understood and managed. Again, we're going to be labouring this a lot today, that acting as a personal representative of a deceased person's estate is a personal appointment where you will be subject to these strict duties and personal liability. It's always better to speak to someone at the outset. The earlier the better, so you can manage all of these obligations you're under. And it is really important to flag now that once you have intermeddled in the estate, which is basically taken on the appointment of a personal representative, it's very difficult to give up this role and be absolved of all these responsibilities without applying to the court for removal. And even if you decide you take on the appointment, want to give this up, this will cause delays and costs, but also up until the point you are formally removed, you are subject to personal liability and strict obligations up until that point anyway. There are quite a lot of circumstances where probate isn't required, and it usually depends on whether an institution is happy to deal with the estate asset or liability without sight of the grant. So for example, values of the assets might be low enough that certain institutions are happy to release what they hold to the representatives of the estate on receipt of an indemnity from them. Assets held as beneficial joint tenants pass automatically to the surviving joint owner, and also pension or life insurance policies written into trust will not require a grant of probate to deal with these, because it's up to the trustees to administer these in accordance with the terms of trust documents. So really what determines the threshold is how an asset is held, the type of asset and the institutional policy.
And I think it's worth saying that today we're focusing on English estates, obviously from our background, but a lot of the estates that we deal with have a very international element to them. So there will be estates, usually an English grant is required where the deceased dies domiciled in England, or they have real property here, but occasionally it will be wider than that. But that doesn't mean that you wouldn't be looking elsewhere. So you might be looking at countries where a grant is required somewhere else first, or you might be looking at, say, civil law jurisdictions where you don't have the same process of applying for a grant of probate. So we would be looking alongside advisors elsewhere to be streamlining that process and making sure that the right steps are taken in the other jurisdictions in the right order.
And I think although there are scenarios where you don't need to get a grant, I mean, most of the families we advise don't fall into this category anyway. But even if you don't need a grant to deal with a certain asset, it doesn't mean that this doesn't need to be reported to HMRC as part of the inheritance tax reporting, and the inheritance tax doesn't need to be paid on these assets. So even where an estate might be close to the inheritance tax threshold, it does need to be looked at, especially in borderline cases, because even where an estate appears to be low value and the grant isn't needed necessarily to deal with the assets, reliefs and valuation principles are easy to misapply, and areas can attract interest and penalties. The nil rate band has been frozen at 325,000 since 2009, but inflation, of course, between that period and now has meant that assets have increased in value. So we're finding that more estates are actually being caught by the inheritance tax net anyway.
And the other point to think about the timing of instructing solicitors is that if there's a risk of a dispute, then it's better to get advice as soon as possible. Now, that might be simply to manage the dispute and stop things escalating any more than they need to be. But it also might be so that the personal representatives, the executor, can take the necessary steps to administer the estate. You might be looking at making sure that it's the right person dealing with the estate, or that someone else is agreed in their place. taking a grant in a contentious estate, or to make sure that a grant isn't taken, to give people time to investigate the issues that are in dispute, come to an agreement, or resolve the issue through the courts themselves. Equally, even where it's simply a case of knowing what your rights are and your duties are, so that you can manage those properly, even going away and having discussions amongst the family, it's still useful to be well prepared in those scenarios.
Yeah, I think that's a really good point as well about this multi-jurisdiction approach to it, and how there are very different rules that can happen. So we know that we have more global, lifestyles now. So I think that's a really good point that you just touched on there. But coming back to England and Wales, could you talk us through the key stages of the probate process, from death to final distribution? So England and Wales focus.
Of course. So the first thing I think that is actually quite easy to forget at the outset of the matter is you need to identify the last will and the named executors, or the appropriate other persons, such as substitute executors, in a scenario where an executor is unwilling or unable to take on the role. Or if there isn't a will, the statutory provisions that apply to the succession of the estate need to be reviewed to determine the order of priority as to who can apply for the grant and act in the administration.
And this is where some of the contentious matters fall at the first hurdle. So some of the areas that Emma and I often overlap are actually where someone needs to apply to act in place of an executor. And that might be with the agreement of an executor who no longer wants to act. Perhaps the will was made some time ago, and they no longer have capacity, or they feel that the appointment would be too much for them, so they might agree to step aside, or indeed where the will has been lost and you're applying to prove a copy of the will, which is often relatively straightforward with assistance, but a process that can be quite daunting without legal help.
And once you've worked out who the personal representative is going to be and how the estate is going to be distributed, the next key stage is valuing the estate and working out everything that you're dealing with, so that the inheritance tax reporting can be dealt with as necessary and estate assets secured. However, there are very few circumstances where this can't wait until you've had the funeral, and you will of course need to register the death before you can begin the investigations into the estate. Still on the inheritance tax line, any inheritance tax due on application of the grant needs to be paid within 6 months from the end of the month of death before interest starts to accrue on all outstanding amounts. But the inheritance tax account itself doesn't need to be filed with HMRC until 1 year of death. And if you file after, HMRC may levy late filing penalties. And it often takes quite a lot of time to fully investigate the estate and obtain the necessary HMRC compliant valuations. And this stage is where a lot of the groundwork takes place. Even modest estates can surprise you, as often unknown assets and liabilities turn up. And the amounts held in accounts can actually be quite surprising, especially when you're thinking about that nil rate band threshold as to when you pay tax if you can't get reliefs. If there is tax to pay or an inheritance tax account needs to be filed, the probate registry won't issue the grant until HMRC have issued a unique code, and that usually requires the payment of tax. And once you've applied for the grant and obtained it, you then need to ensure that all liabilities have been settled, including outstanding tax, and you will need to collect in the estate assets. And again, broadly, once that stage has been completed, you can then distribute the estate in accordance with the terms of the will, or if there isn't a will, in line with the intestacy rules, which is the statutory order of entitlement. You must be able to account to the beneficiaries as to what has happened to the estate and how their entitlement has been calculated by producing full estate accounts for the administration period. And the estate accounts essentially tell the story as to what's happened and why they are getting what they are up until the point of final distributions. And personal representatives must be able to provide an inventory or accounts upon request at any time. So that's always important to bear in mind too.
Wow, there's a lot going on there. You can see how somebody, especially when they're going through the grieving process, could be absolutely totally overwhelmed by this. And so it is, how key it is to actually be informed for these eventualities. So yeah, really, really appreciate you running through all of this. But let's look at that realistically. How long does probate take? That you just shared that there's a lot of administration that goes on behind it. And what factors most commonly cause delays on this as well? Because you can see there are quite a few moving parts.
I mean, I know Hannah's going to laugh when I say this, but in principle, it's perfectly possible for straightforward estates to be administered within 12 months from death to final distribution. However, most of the estates we deal with end up taking much longer due to various complicating factors, and this includes complex asset structures, tax, which doesn't just include inheritance tax. There's income tax and capital gains tax considerations most of the time, and dealing with HMRC and claims made against the state means that the process can take years to be finalised.
And I think you've mentioned tax not just being inheritance tax as well there, but also thinking again at the kind of international estates that we often deal with. There may be tax returns to file in different countries. There may be grants to obtain in different countries in different orders. And so that can all cause a delay, but it's important to make sure that you are dealing with the English issues alongside and not simply leaving those for later and missing, as you say, the kind of filing deadlines here and that kind of thing.
But again, taking the wider estate administration process into account, everyone always thinks of probate registry delays, and actually applying for the grant takes a long time, which it does, particularly paper applications, which are usually more complicated applications and usually involve a non-UK deceased person who you need a grant to deal with their English estate. However, probate is just one of the milestones in the estate administration process. And other delays can result from investigations into the estate taking a very long time, and these can be made more difficult and lengthy where there have been poor record keeping. There are overseas assets that you need to look at, and sometimes the pace in which you get this information isn't as quick as we'd like it to be. And also the reporting errors do delay things as well, such as missing lifetime gifts, which impact estate tax, and disputes over valuations and HMRC's queries really do, unfortunately, slow the administration down.
I think also it goes beyond legal issues, doesn't it? So a lot of them can be caused by, more human issues, emotional issues, or the disputes that arise from more human elements of the process. So it might be executors who are jointly appointed but can't agree how to move forward if they're unfamiliar with their duties or the requirements that they're subject to. Or who decide very late in the process that they want to renounce, and then there's, there has to be an application to court, which could potentially be avoided. Equally, you get the family disputes, which are the combination of emotional and legal, so whether that's will challenges or interpretation of the terms of a will, or just sometimes decision paralysis from those that need to be making the decisions, the executors.
Yeah. Because I can imagine some of these decisions are weighty on a family later, and the consequences of making those decisions now can be quite disruptive, because some of the beneficiaries or may have been expecting something that they're not, and that had never been discussed during the deceased lifetime, and so there may be some shocks which will provide some of these hiccups, which is where, Hannah, you come in to try and dissolve the disagreements. But I guess let's look at something a little bit more positive now, and from your experience, what steps can individuals take to be best prepared during their lifetime to make sure that it's not so much of a headache when they go?
I mean, the thing that instantly springs to my mind is having a will in place that achieves what you want it to achieve. It's therefore crucial to regularly review your will, and it's usually when life events happen, so marriage, children. But equally, what you want to happen in your 20s won't necessarily reflect what you would like to happen to your estate in your 50s. So really, it's just keeping it under regular review to make sure it reflects accurately what you would like to happen.
And that certainly reflects where I find that disputes arise. Often it is simply because life has overtaken the planning that you've engaged in. So if you have made a will when you're younger, you might have appointed, people of your parents or people of your parents' generation as executors. And as time moves on, that's not appropriate. Or if you've made a will, when you're single and then you're cohabiting with someone, and that can be, earlier in life or later on in life. You might be maintaining someone later in life. And again, if you haven't made the provision for them in your will, then there can be potential claims. Whereas if you've given that some thought during an estate planning exercise, so you've gone to make a new will and thought about who might have claims on your estate, that can head off a lot of the challenges. The other benefit of reviewing your will regularly is that if later in life usually later in life, there are capacity issues with the deceased making a new will such that that will can be challenged. Often if you've kept things under review, the changes are likely to be less significant on each occasion and less more difficult to challenge post-death. So again, not leaving things too late, but also keeping things under regular review can really help.
And I guess another point that I would like to mention is that if you are making use of lifetime gifting in your estate planning, then accurate records need to be maintained because the tax benefits are claimed on death, and it can be an expensive and time-intensive exercise to reconstruct these records. And just on that point generally, keeping good records and having someone you trust know broadly what your estate is comprised of and where to find these details will help streamline the investigative stage of the administration process. And it's also important to think of things like digital passwords and your keys for your crypto assets, and that these are stored in a secured way and people know that you have them. Record keeping also doesn't just mean your bank statements and your investments. It also applies to personal paperwork such as divorce paperwork, marriage certificates, death certificates, and so on. And that's quite a broad category. And I guess your record keeping is personal to you and what your circumstances are.
And I think to that point, the same applies whether it is an individual keeping their own records while they retain capacity during their lifetime, or whether it's someone acting on their behalf and stepping in as attorney or deputy. So sometimes that attorney might be, continuing the process and will take over as executor when the deceased passes away, or sometimes they will have to hand over to a new individual. But either way, to Emma's point, it is much more difficult to reconstruct records later on than it is to maintain them as you go along. And the closer to the source, so immediately upon an attorney taking over, to make sure that those records are as complete as possible is going to be very useful in the longer term. And I think to that point, it is always less costly and stressful to deal with these things during lifetime when you can deal with them yourself than it is for those who are left behind later to have to deal with them and the disputes or the delays that can arise if you haven't sorted them properly.
So go.
Carry on. I was just going to say, so practically speaking, it's just making your decisions in advance, leaving a clear paper trail as to your decisions, and reducing uncertainty as much as you can.
Definitely. So one question and one thing that has arisen previously is, how do you know that you have the latest copy of the will? And I think this is one of those that are, how do you know? Because if somebody, say, updated their will, hasn't informed anybody, you're going off a will. Sorry, this is curveball. How do you know?
So I think that is one of the areas that we end up in dispute. And I suppose we see it more often where someone is challenging a final will and saying that that one would not be valid. It is difficult, and you can be expected to undertake some research into potential wills. So you would often approach the firm who had made the last will that you were aware of to see whether there was a later will. There are databases for registering wills, so you can carry out searches there if there is any uncertainty. Equally, just looking through the deceased's paperwork at home, making sure that you have had a good look. You do have to declare as an executor that this is the last will that you're aware of, and so you have to have undertaken a reasonable level of search to be able to make that declaration. Some of it will come down to the date of the will. A will dated 2025 is much more likely to be the last will than a will dated 1985, but that's not to say that we don't have those scenarios. Yeah. Is there anything that you would add from a
No, I'm just thinking, I did work on a matter with Hannah, and we were looking for a codicil, and it did end up being in the top drawer, and we were asking for stamps, can we please, check? And then it did turn up in a top drawer of a desk, which was,
Well, I think, but wasn't in the safe.
So but wasn't in the
safe.
Naturally
about where papers might be kept. The safest or the most obvious location isn't always the only location.
Mm-hmm. Yeah, human nature. We're managing humans here. This is the interesting part of it. But that, again, you touched on some of the duties of the executor. And you mentioned this at the start, so that there's personal liability. What does that look like? What is that personal liability? And what are the legal duties overall for an executor?
When we were thinking about this, you could do a session on that alone. But one of the main takeaways that is coming out of today's session is the personal liability that an executor has and all these duties that they're supposed to be thinking about. So there are some key themes which should always be borne in mind, and that is always acting in the best interests of the estate, and remaining a neutral party and acting impartially. They should also be protecting and preserving the estate throughout the course of the administration, and just be administering it with reasonable care and skill.
And I think that can express itself in quite different ways. So, for example, one of the ways that we come across this is where an executor might also have been attorney during the deceased lifetime. They might also be a beneficiary of the estate. And they're wearing multiple hats, in a sense, during the administration. So it's very important to separate those roles for them to separate those roles in their mind. So, for example, where an executor is making decisions, they must make sure that they don't prefer their own position as beneficiary over the position of the other beneficiaries of the estate. And that can sometimes be particularly difficult in cases of dispute, but also, if someone wants to buy out an estate property or those kinds of things, it can arise quite easily. And so that's one of the positions where sometimes you end up with multiple solicitors involved, even in a relatively straightforward estate, because they might need advice in one capacity, but also to have separate advice very much with a different hat on, so as executor and as beneficiary, for example.
And again, I guess it's not forgetting some of the more obvious ones, which is administering the estate in accordance with the terms of any will and to keep good accounts. And a personal representative is a fiduciary, and that means they hold a position of trust and are subject to these strict duties. And it's not really a best endeavours obligation. And I think most people sort of think of this role as quite symbolic, but actually being a personal representative is one of real responsibility. And due to this, they can be held personally liable for breaches and be personally required to repay losses to the estate, which could mean funding shortfalls from their own resources. So liability isn't just limited to the estate assets. And of course, a personal representative can reduce this risk by taking professional advice, advertising for creditors, waiting for appropriate periods before making distributions, but also not being pressured into rushing distributions, and retaining a reasonable reserve until things like the inheritance position has been fully agreed with HMRC.
And I think I'd really...
Sorry. Just before you start, we do have a question coming in. So after you do that, we'll then ask the question, if that's okay with you.
Of course. I was just going to say, I would really reiterate what Emma's just been saying. There are really a lot of traps for the unwary, and a number of disputes I deal with arise from executors who were acting in good faith, but actually without really understanding their obligations. They have, for example, not properly accounted for the estate, and unnecessarily often caused questions to be raised that become very lengthy to resolve and raise more suspicion. Or, for example, because they've missed a deadline to pay taxes or to vary an estate, which has then caused the tax burden to be much heavier than it would otherwise have been.
Yeah, that's really, really important to note. So question just coming in. How do you manage that being if an executor seems to be favouring their own beneficiary interests if you are advising someone? Does it create conflict in terms of who is your client?
So we would usually in this scenario be thinking with our probate hats on, we would be acting for the executor, and we would be acting for them in that role. So in that sense, if there is an issue that arises where where an executor is inclined to prefer their own position, we would often have to send them to another solicitor to take advice. So we would be saying, as executor, you need to weigh up these issues. But if as beneficiary you want to make a claim, or you think that things should be dealt with in another way, that may be something that they have to take up with the other beneficiaries as beneficiaries, and then that gives rise to a dispute there. Or it may be something where they actually need to instigate a claim against the estate if it kind of tips over that threshold.
And I think, well, even in your executor role and beneficiary role, if you can't separate those two hats and act neutrally and impartially, but also, you're still favouring yourself as a beneficiary, then there are grounds that you can't administer the estate, and you could end up being removed, and an independent executor having to come in and be appointed as well, which is always a risk.
A risk and a cost risk as well. It can give rise to additional costs for the executor who hasn't been able to separate. So, to the extent that they're able to do that, it's always preferable, I would say.
Sorry, another question. They're all coming in now. Can the executors value the contents of a house of the deceased estate, or do you have to, I think we're coming up to this, but I'll just finish this question. Or do you have to have a professional company to do this? If yes, are there guidelines to follow? Shall we come to that when we get onto the valuations section? Or do you want to answer that now?
Yeah, let's touch upon that in the valuations section.
Yeah. Actually. So we're just following structure. We like structure. What are the most common pitfalls, particularly when estates are complex or emotionally charged?
I think it's important to acknowledge, and everyone needs to acknowledge, that bereavement is one of the most stressful things that you will need to navigate. And everyone deals with their grief differently. And adding on top of that, administering an estate can amplify emotions and be very overwhelming, especially because you won't have the clearest of heads to deal with it.
And I think broadly, there are certain types of dispute which will always arise, which are very difficult to avoid. But good planning during lifetime will help avoid a lot of those. So, for example, if you've got disputes arising from legal or factual uncertainty, then having a conversation during lifetime can head off some of those. But also things like timing mistakes, valuation, we'll come on to that in a minute, and allowing emotions to drive key decisions are certainly things to look out for, be wary of.
And also, given that they are emotionally charged affairs, and we've just touched upon it a moment ago. It can be difficult to remain neutral where there is conflict between those close to the deceased or with how people think an estate should be administered. So it's always useful to have an independent person, such as a solicitor, involved who can help you take that step back and view the situation more objectively. And it's also important for beneficiaries of an estate who might be unhappy with what they're receiving or the way the estate's being administered. And as I think people hopefully have gathered, the estate administration process is extremely bureaucratic with various deadlines. And having someone help you with the day-to-day administration can really take the burden and stress off of you and give you the space you need to navigate your own grief. And again, it's really important to appreciate that everyone deals with their grief differently, and there is nothing wrong with seeking support, particularly given all of these obligations and duties and liabilities that we've been talking about.
And I think to the point about grief and trying to limit the emotional toil, actually having the conversations during lifetime. So a lot of our disputes arise from deceased who have not faced up to the complexities of often their family situation rather than their assets during lifetime. And had they had those conversations during lifetime when the family members could have spoken to them about it and understood why they were making the decisions they were making, that might have headed off some of the upset, the emotional turmoil that comes from equating the money that is left to a particular beneficiary with the amount of love that was felt towards them by the deceased.
Yeah.
And I guess just another pitfall, which again we'll go on in a moment, because clearly that it's a question that everyone asks themselves. It's the nuances of the estate administration process, but that does include the valuation principles, and again missing the key deadlines.
Yeah. And then I think it's all right. Thinking about international estates again. I think it can be really important to make sure that you're receiving joined up advice and advice in all of the relevant jurisdictions, because we do find that there's a need to project manage large estates across multiple jurisdictions, because otherwise it's very easy for particular issues to fall between the cracks, or where there are conflicts of law issues for them not to be raised. Rather, instead, each jurisdiction might be thinking of themselves as a bit of an island, and not doing that joined up exercise.
Yeah, I mean, I think the ultimate thing is just don't die. That would be a real solution to all of this, guys. But no. And coming back to the question that was asked a moment ago, how are valuations handled, and what happens if the assets are later found to be under or overvalued?
So I think the basic rule for valuing assets and liabilities for inheritance tax purposes is the values that you return to HMRC must be the open market value at the date of death. And this valuation is fixed at that date. And essentially it just means the price the asset might reasonably be expected to fetch if sold on the open market at the date of death. And it applies regardless of whether the asset is actually sold and what ultimately happens to it. Personal representatives or executors are responsible for the valuation and must use reasonable care and skill. So obtaining professional valuations does help to justify the valuation used, but any values returned, ultimately the executor has to be able to justify that that is the true inheritance tax value. But using a professional doesn't transfer the responsibility to them, but it does demonstrate that you have taken reasonable care with obtaining it. And then different asset classes have different valuation principles. So quoted shares and investments are typically valued using the mid-price or quarter-up method. Unquoted shares and business interests require specialist valuations and are often subjective and contentious, especially if you are trying to get business property relief. And these normally trigger an HMRC inquiry. Property valuations should usually be handled by a RICS qualified surveyor and should reflect the actual condition on death and market condition at that time. HMRC are regularly reviewing property valuations via the Valuation Office Agency at the moment, and these valuations are one of the more frequently challenged classes of assets. And going on to chattels, art, jewellery, it's very easy to undervalue these. And again, some of these usually require specialist valuers. Overseas assets will also need to be carefully valued, and any values converted into sterling at the appropriate exchange rate at the date of death. Probate can often proceed even if HMRC are reviewing valuations and raising questions. And if HMRC raise questions into the IHT account, they may ask for further evidence of the values returned, and that does include household and personal items in the property. They have the remit to refer the valuations to specialists, and they can open a formal inquiry, particularly where there is a property, business interests overseas, and any inheritance tax reliefs being claimed. And of course, any of this will increase the length of the estate administration. If an asset is found to be undervalued, this is where the risk for a personal representative increases considerably. So interest accrues on the outstanding inheritance tax that falls due, and it won't be waived by HMRC, but they may also issue penalties where they have found to have been carelessness, deliberate understatement, or failure to take reasonable care in obtaining the valuation and sending it in the inheritance tax account. And again, as we've mentioned throughout, there's personal liability here for the shortfall. If the estate has already been distributed and the assets can't be recovered from beneficiaries. But if you've sought independent professional valuations and you've been transparent in the disclosure of the estate and justified the valuations you have returned in the inheritance tax account, or where the values were genuinely uncertain or subjective at the time of submission, this will all assist with you showing HMRC that you have taken reasonable care in reporting the estate to them.
Sorry.
No, carry on.
Another question.
Yeah.
How often are valuations challenged by HMRC?
At the moment, so I have noticed in my particular caseload, bearing in mind I tend to deal with the more complex estate administrations, I would say that I have seen quite an increase in questions being raised. Particularly, that's why I mentioned the property valuations being returned at the moment. And more often or not, they are being sent to, in my case, the valuation office for them to review. Sometimes they come back and say, yes, all is fine, or sometimes they send the comparables that they've used. So I do think it's one of the biggest areas of risk with HMRC, and they are definitely looking at things quite closely at the moment. And especially if there's anything that's slightly different. So I don't know, there's a loan, or again, there's a business interest, or a large amount of lifetime gifts that you're trying to get exemptions on. More often than not, HMRC, will flag these accounts and we'll take a closer look at them.
And then also, how do HMRC know when it comes to things like chattels?
No, you sound like my dad. He always says this to me, but how will HMRC know?
How will they know? They'll know.
And I just have to say, with my professional hat on, well, one, I always say to clients, if you have a property that's worth £2 to £3 million and you put 0 for personal goods, that is a red flag in itself, because you're not telling me that someone doesn't have any, even, and I know that's, for example, furniture has decreased in value if you're using the open market value principle. And going back to the question you asked earlier, if you've, done a sort of inventory and said these are all of the items, then HMRC might double check and ask you, you know, on what basis did you value these items? But it's always good, I think, as well, if you are administering an estate, to get someone in anyway, because then you've got an inventory ready to use of the assets. And also, to the untrained eye, someone might look at something and think, oh, that, you know, that's not worth that much. And then you realise, you know, a bit like, you know, the auction.
Cash in the attic.
Yeah, where then suddenly they're like, oh, it's worth, and that has happened to me, where I've been like, oh, okay, we'll get someone in, and then found out that, you know, there's a £50,000 piece of artwork that everyone else would have just put past.
Yeah, or the other way around, actually, where you've got artwork which you thought was authentic and valuable, and then when you have someone in to value the collection, it turns out that one of them is a fake.
Yep. Yeah, well, it's important to keep on top of that, especially if you've got collections.
Absolutely. In that scenario, if it had been overvalued, what you'd do is you'd submit a corrective account to HMRC, so that figure can be used to calculate the inheritance tax. And if they agree, you can get any overpaid inheritance tax refunded. And there are also some reliefs that you can get if you know, the property market's gone down by the time you sell it. So what you've reported as the date of death value is, you know, more than the sale value. You can substitute or apply to substitute that value, providing certain criteria is met and the property is sold within 4 years of death. So I guess some practical tips that people can keep in mind when it comes to valuations would be, you know, obtaining written professional valuations for material assets, but also keeping a paper trail of what you have said to them, you know, just to make sure that you've given them the right instructions. And, you know, because sometimes they might give you a probate valuation but not give you one that's upon the principles that they should be valuing it. Keeping clear, you know, just evidence, and again, just avoiding early full distributions in the estate until all of this has been agreed with HMRC, and keeping a suitable retention in the estate pending tax clearance. And always, again, you can ask for assistance if HMRC do query valuations returned, because the more informed you are, the easier it is to deal with the questions asked.
Definitely. So I guess let's go back to early steps. What early steps can executors or families take to reduce the risk of disputes?
So I think some of the key themes are that often people allow emotions to lead the conversation, and that can allow things to escalate very quickly. So where people are not necessarily separating their roles in their own mind, or emotions are just running so high that they can't really help that. Or at the other end of the spectrum, you have individuals who are so preoccupied by smoothing things over and not allowing things to escalate that they really let the protection of their own position fall by the wayside in a way that often people regret slightly later down the line, or can do them a disservice when they come to try to negotiate their way out of a dispute. And I think the important thing there is to take good advice. Now, that doesn't have to be you know, it doesn't need to mean getting a solicitor involved at the front of it. You know, it can be taken in a mindful way so that you are informed rather than coming across as aggressive or combative. But sometimes having a solicitor writing the letters or you know, taking that front-facing role can de-escalate things if you've got you know, other family members or potential claimants who need to see that you're not just going to let them walk all over you. So those are some early steps. I mean, obviously, ideally, the early step is to have the estate in a good state prior to the deceased's death. But I suppose we're thinking about what you can do if that hasn't happened.
Yeah, and I guess if a dispute does arise, what are the practical factors?
So I would say it comes back to the point about it's important to understand your own position, and that normally is by instructing a solicitor. It's important to understand what your obligations are, what potential claims or defences you might have if issues are being raised, what steps are appropriate to take for different parties to investigate, where you are the executor, making sure that you remain neutral. But equally, that doesn't mean you can't do anything. It can still be appropriate to undertake certain investigations. For example, to the point about making sure that you've got the last will, the most recent will, as executor, you can still take certain steps to confirm that. It's also important to realise that it's not just about having legal advice, because grief and bereavement are such an emotional time. It's very important to have all of the right team in place. And so sometimes that can mean having the right outlet for therapy or financial advice, and not just the legal side of things, because we're not the best place to advise on everything.
Yeah, that's such a good point, and I think something that is often sort of lost in the chaos and the grief process is actually there is a triangle of advisors that you really do need: someone financial, someone legal, and someone emotional, in order to keep you going through. So look at it as an arrow pointing you in the right direction. Getting those 3 points together is key.
Yeah, and that direction for disputes doesn't always have to be towards court as well. It can be sitting down, and the court really encourages alternative dispute resolution and mediation. So from that informed position, it can be really useful to go into a kind of settlement discussion and to try and resolve things. I often say to clients that, you may not want to speak to your step-parent or your siblings ever again, but you might want your children to be able to have a relationship with their cousins, for example. And that's something that you can reduce the impact of the dispute, particularly on other members of the family, if you can resolve things in a more collaborative way.
Yeah, I love that point. And it's so important is the decisions that you're making aren't just affecting you and destroying a family extension from yourself because of something that is maybe a financial dispute. Can be hurtful for the longevity of the family unit. And it's important that you do it correctly. So last but not least, for someone who's about to face probate for the first time, so anyone who's tuning in, if you're watching this now or on the replay, if you've never done this before and it's something that you are facing, ladies, what is the single most important piece of advice that you would give to them?
I think mine is you shouldn't underestimate the emotional toll that a bereavement takes on you, and that you don't have to do it alone. Because as we've mentioned, you do need your triangle of advisors, but also you shouldn't neglect, again, speaking from a legal perspective, we can deal with that, but you shouldn't neglect the grief process and appreciate that it's not a completely linear process either.
I think I would say very similarly, you need to get the right legal advice, but you need to separate that legal advice from the emotional side of things. Give yourself the time and the space to deal with the grief alongside, and consider your whole team.
Lovely. Well, thank you so much. Thank you to everybody who asked questions. For anybody who wants to ask further questions, as I mentioned before, please do reach out to myself, to Hannah, or to Emma. Really appreciate your time. Thank you, ladies, so much for that. It was really, 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 really important and interesting. So thank you.
Thank you, Lottie.
Thank you. See you soon. Bye, everyone.
Bye.